morning's docket. Case number 113235 in the matter of Rustin Kent Rankin.
May it please the court. I'm Alexander M. Walczak, Deputy Disciplinary Administrator. Mr. Chief Justice, with the court's permission, I'd like to reserve 2 minutes for rebuttal.
2 minutes is granted.
Thank you. This is the original case of attorney discipline. The formal complaint in the case alleged that the respondent violated a number of ethical rules in his associations in dealing with an elderly, wealthy widow client. At the 2-day panel hearing, which occurred on October the 29th and October the 30th of 2014, the respondent stipulated to one of the charge rule violations, specifically acknowledged that his conduct violated 1.8. In that first, he received a loan from the client for $15,000, and secondly, by transferring client money and property into a limited liability company which he established, in which he became a 50% owner. The respondent did not contribute any assets or any capital to this. It all came from the client. The respondent disputed the other charge, allegation, and rule violations, and at the conclusion of the panel hearing, the hearing panel found by conclusive evidence that the respondent violated 4 different rule violations. They found a violation of 1.5 by failing to charge a reasonable legal fee, and what the panel highlighted as to that finding was that he created 5 invoices reflecting legal retainers totaling $60,000, which was purportedly for work completed 2 years earlier, as well as failing to communicate with the client the basis of his legal fees during the period of representation. The panel also found a violation of 1.782 in that there was a concurrent conflict of interest with the representation of the client and his own personal interests. And his personal interest was that he was a business partner with the client as a result of this limited liability company that he established, as well as he became the sole heir under her will, which was changed during the representation, and as well as he was the beneficiary of a very large IRA, which also occurred during the representation. The panel also found a violation of 1.15 in that the respondent failed to properly safeguard the client's property, in that during the period of representation, at the minimum, $169,653 is unaccounted for, which was of the client's ownership, as well as that he commingled in his client trust account personal funds belonging to himself with that of the client in this case, as well as other clients. Lastly, the hearing panel found violations 8.4c in that the respondent engaged in conduct involving dishonesty when he backdated billing records and he did this in 2012 to reflect the $60,000 legal retainers in 2010, as well as when he transferred a property which was labeled as a Duhaney property from the limited liability company to himself without the knowledge and permission of the client. The client, again, was a 50% owner of the limited liability company, as well as, prior to that, the owner of the real estate. And third, by considering the totality of the circumstances during the representation, the panel found from 2008 to 2012 was self-serving and self-enriching. the respondent, on review before this court, did not file any exceptions to the findings or the conclusions of law. At the panel hearing, the disciplinary administrator recommended disbarment. The respondent maintained that the appropriate discipline in the case was a censure, and the censure be published in the Kansas reports. The hearing panel, while considering respondent's misconduct and labeling it very extreme, very egregious, held that disbarment was warranted. However, they recommended that in light of the presence of the mitigating factor that this was his first record of public discipline, that indefinite suspension was appropriate. Before you today, I'm recommending that the appropriate discipline of the case is disbarment. The mitigating factor with the hearing panel hung their hat on that of being no prior attorney discipline. While that's important, I would suggest that all attorneys have a professional obligation, affirmative duty to obey the rules of professional conduct and comport their conduct and be above law. And the ethical rules are really the framework or the minimum. There's more owing as a professional. Especially in the light of this case, the weighing of that particular mitigating factor should not outweigh what the panel found. And I'd like to highlight some of the findings. That the misconduct in this case was knowingly, caused actual injury to the client. There was a pattern of misconduct that spanned at least 3.5 years, and the victim was vulnerable. The panel labeled some of the respondent's testimony and his explanations as to his conduct as inconsistent, cavalier. Again, the panel found that the appropriate misconduct warranted disbarment, and in this case, the disciplinary administrator is asking you to affirm the findings, affirm the conclusions of law, and adopt the recommendation for disbarment. That concludes my remarks, unless there's some questions.
Any questions?
Do you know or have an opinion as to is there a dollar figure associated with the actual injury that the clients suffered in this case?
I don't have a good handle on it. There were 3 different accountants looking at it and could not establish a firm amount. We suggest, and the panel suggests, that the best amount, at least $169,000, and right around there, was unaccounted for.
So at a minimum, is it fair to say it's at least your position that the $150,000 settlement did not entirely make the client whole?
No. The respondent did, for the panel hearing, retain a CPA. He did not. None of these CPAs did an audit. They couldn't. The respondent's CPA did a sort of a snapshot of only the calendar year 2009, and only looked at 3 accounts. It was a very limited looking or analysis, and that particular accountant said it was like $65,000 for the year 2009 that was not accounted for. The accountant that the disciplinary administrator used suggested $169,000 or $165,000.
Any more questions? Thank you, counsel.
Thank you.
John Ambrosi, on behalf of the respondent, may it please the court, Mr. Chief Justice, Your Honors, we agree that the facts as laid out in the panel report are accurate. And we agree with the findings as far as the violations that panel found. I want to answer right away the question that you posed, Your Honor, if that's okay. Look at paragraph 59. Lawyers must safeguard their property, et cetera, et cetera. he was unable to account for at least $65,364 or as much as $169,653. That's because of his failure to account for the money. So there was a figure arrived at, and the $150,000 that he paid, the $100,000 through the malpractice carrier, and $50,000 of his own money got us somewhere to where that person was made whole. We don't know. How can we know? We don't know why the civil case was settled for that amount. There were good lawyers involved on the other side, good lawyers involved on the defense side, and they agreed at that figure, and everybody seemed happy with it.
Was the $100,000, did that represent policy limits on malpractice?
$100,000 was his policy limits. Yes, Your Honor. The $50,000 came out of his own pocket. I thought I should answer that right away because I do disagree with my colleague as far as that's concerned.
Let me ask you, one thing that bugs me is you come here and you say the facts are accurate, yet when I read the answer that you filed to the disciplinary panel, you denied facts in existence. And I can't reconcile that. I don't see how certain facts are told to everyone in a pleading that they're wrong, and then when the hearing panel gets done, all of a sudden, well, okay, they're right.
Well, they made the determination, Your Honor. We don't file general denials, as you know, in disciplinary cases. We're supposed to lay our own factual scenario out. And it's a liquid thing, and it's always moving and moving and moving. In the case I argued this morning, the facts were pretty obvious. Everything was admitted. In this case, it was liquid. We were still trying to figure out what the facts were the week before. We had a meeting with my colleague, Mr. Walzak, another lawyer in the office, Ms. Baird, and their accountant, just trying to figure out where the facts are. It may have been 2 weeks. So this was very liquid. But we have no problem with the facts as stated by the panel. And I'm not fighting with you on that, but it's a liquid situation in these disciplinary cases.
One of the facts you denied was the respondent's record keeping, whether it was any good or not.
It was atrocious.
Well, but you said it wasn't perfect, but it wasn't bad. That's what you denied. And,
That's correct.
And this, it seems to me, circles back to the panel's determination about the respondent's attitude, and that weighs very heavily in terms of figuring out what the appropriate discipline is.
And I agree with that. It does weigh very heavily. We had a hard time, all of us, and when I say we, I don't just mean the respondent, but the disciplinary administrator's office, trying to figure out what the facts were. How did this get so screwed up? How was the trust account in such terrible shape? He was a terrible record keeper. That's why we couldn't figure out what the loss was. We're pretty well convinced that all the money's been accounted for, but he didn't have the receipts. He couldn't show where that $62,000 to $195,000 or $160,000 went. We think it was paid for out of his trust account, but the record keeping was atrocious. He never learned how to run a trust account. He was never taught. He needed a monitor on that trust account. If there had been, and this is not the fault of the disciplinary administrator's office, if there had been a trust account audit 4 or 5 years earlier, they would have thrown up their hands and they would have had him reorganize his entire trust account. So the disagreement was how much was gone. And my duty is not, as an advocate, is not just to agree with everything they say, but to disagree in that pleading as to the situation. I hope I've answered your question.
Well, counsel, can we back up from the poor record keeping for a minute and just let me ask you straight up, why was the money gone? Why did your client do this?
I think I know what happened. And I believe this came out during the course of his testimony. He got very, very close to this woman. She became like a mother figure. I think he said in the transcript, she became closer than my own mother was. And then she trusted him with everything. She wanted to invest in a restaurant. She wanted to invest in property. She wanted to build a house. And she didn't want to do it. He, as her friend, as her son, took that on himself, and the money flowed into his trust account. He knew enough from law school that it wasn't his money, and that IRA had to be transferred in to a trust account. But then he just wrote checks when she needed the money. He just wrote checks when she had a bill. He just wrote checks, etc., etc., etc. There's no excuse, Your Honor, for this atrocious, absolutely incompetent record keeping. There's no accused, but there's no evidence that he was a thief. There's no evidence that he was
Well,
a brigand.
that goes to the heart of my question, right?
But, Your Honor,
Because it appears the panel found that he was stealing money, and then when it came time to pay it back, he couldn't account for where it went because of the poor record keeping.
the panel felt on the $60,000 where he was taking so 20,000, 20,000, 10 and 10, or maybe in a different way, and then that was for attorney fees when he wasn't keeping jelly chits like we've all been taught to do, and then to reconcile it against the account before you send out a bill. He wasn't doing that. They thought he was dishonest there because he made up those records, those chits, those timesheets after the fact. They found he was dishonest there as far as drawing down the money for attorney fees. They didn't find that he was dishonest in stealing money out of her IRA. And I understand your question is, isn't this thievery? And your question, and the panel looked at that pretty carefully. And I would think that the panel thought he was a thief or a brigand, then they would have recommended that he would be disbarred.
Well, they said it was extreme misconduct and warranted disbarment.
I agree that it was extreme conduct, and I'm asking because this...
So you're not, I mean, because it seemed like you started out arguing this was basically, we could chalk all this up to maybe extreme incompetence, but not dishonesty, not thievery.
He was incompetent. He was a bad record keeper, Your Honor. I do not think the evidence shows that he was a thief. I think the panel would have said, this was a good panel. They're all good panels. They would have said, this is thievery. This should be disbarred. If they thought he was a thief, they wouldn't have given this chance. They wouldn't give him this chance. That's my interpretation of it. Mr. Cohen's questions, who was one of the panel members, he was the at-large member, were pretty intuitive and honed in on just that. And the cavalier attitude, which was alluded to in the panel report, it's just my client's countenance. It's just like everybody's countenance. People tell me, Ambrosio, you always look angry. And I do. That's part of me. That's part of me. It doesn't mean I'm always angry. He always has that countenance like nothing's a big deal. That's part of him. He wasn't disrespecting the panel or his client or laughing at the disciplinary system. They indicated he didn't get it. He got it. I just think that's the way he reacts to things. And I think that's important we look at that. I'm asking because he started out doing this behavior, carrying on this behavior when he was just out of law school, 1 year out of law school, that he be suspended for a finite amount, which would be 2 years, and then have a reinstatement hearing where we look at everything, his finances, his tax returns, and everything, to see how he is before we allow him to practice law again. And my client agrees with that recommendation and does suggest that recommendation. I thought you were going to ask me something.
I just was seeking clarification from your responses to my colleague's question. This is not, in your view, just a matter of your client being a poor bookkeeper. Is that right?
That's correct.
All right.
That's correct. That's correct. I'm not so foolish to make that argument. There's only so much you can do as an advocate. He was wrong. He did wrong. He was sloppy. He was foolish. He got too close to the woman. He was in a conflict situation. He was not at arm's length when he prepared documents. He should not have gotten involved or to that point. Why he did it, we only can describe and explain to say she became a mother figure to him. Without any further ado, my client would like to address the panel, would like to address the court. Thank
That'll
you.
be fine. Thank you.
Ladies and gentlemen of the court, I come up here to apologize. These were my mistakes. These were the failings that I made, and that you guys trusted me with a law license. And while I did a lot of things, I just didn't do enough of them. When I entered into a business arrangement, I contacted Mr. Depew, and Mr. Depew explained to me what I needed to have set up to engage in a partnership with her. The problem is I didn't do enough. I didn't follow up on that. Those are my faults. Those are my misgivings. Those are my failings. And I didn't do a good enough job. I failed her because I was the attorney, and she expected me to handle things correctly and better than I did. I apologize. The receipts that can't be found are the receipts that I gave to her, and she doesn't have them. But I should have done a better job. I should have kept a second copy. I should have protected myself. But it never dawned on me to protect myself because I was so close with this. When we traveled, we did a lot of things together. But I should not have let that so affect my judgment as to not treat her like the client that she was. And that was my mistake. I have admitted that. I should have done a better job, and I feel terribly about that because it has taken me a long time to realize that. I mean, at first, of course, I was angry and I was upset, and then I sat down and started thinking about what was my job, what was my role, what should I have done, and every time that I got to a point where I said, oh well, this should have happened, I look back and I go, but that's my responsibility. I should have kept better records. I should have made duplicates of everything. I should have forced her to get an arm's length transaction when we transacted the LLC, even though she said she didn't want one. Because as I look back now, on the outside, it looks a lot different than it was when we were together and she was at my office or she was at my house. And I look back now and I realize that that I treated her too much like a friend and not nearly enough like a client, and that those failings fall directly to me, and there's no one else to blame. I feel terrible. I have, I've attempted to make amends with the insurance settlement. I tried to be the best friend I could possibly be to her, and as it turns out, I should have worked a little harder at trying to be the best attorney that I should have. I would just point out that this is one client when I first got into private practice that we became friends with. Since this has happened, it's been 3 years. I've practiced and done very well and haven't had any issues or problems because I realize my personality is not one when I let somebody in to be able to keep them at arm's length. And so we have a new set of rules at my office. And I truly grasp and understand the mistakes that I made. And as God is my witness, I can guarantee you I will never make those mistakes again because I'm the one who swore an oath. And I'm the one who said that he would conduct himself based on the rules of ethics, and I let that lapse. And for that, I am incredibly apologetic. I'm apologetic to her, I'm apologetic to you, I'm apologetic to the law, the practice of law in general, because it makes us look bad, and I was part of that. And I apologize. I can't say that enough. All I can tell you is that I did it because she was my friend, and I cared very, very much about her.
Counsel, I appreciate your comments today, and so I'm going to ask you to respond to what the panel found in their finding number 77 and ask you to describe the difference. In the hearing panel's observation, it appeared that the respondent was cavalier in his approach, and he failed to grasp the gravity of his failure to adhere to the applicable sections of the KRPC. And then here's the part I'm particularly interested in. Overall, it appeared that the respondent failed to appreciate the situation in which he now finds himself, and more importantly, he failed to understand the substantial injury he caused to the client and to the legal profession as a whole by his egregious misconduct. The hearing panel is troubled by the respondent's attitude, unquote. So my question is, what you've told us today in front of this lectern, is that what you told the panel? Or were you not given an opportunity to speak like this? Or there appears to be some inconsistency here.
I can tell you how my attitude was before the panel, and it was the fact that I had just gotten on a drug called Beryl-Tex, which deals with depression, and I was just getting on that and I had a lot of emotional difficulty until I sort of got used to that. What they took as cavalier, it was not cavalier at all. It was me adjusting to a situation to where I was taking antidepressants for the first time, and their effect on me. And I believe in my hearing I did apologize, not I assume to the extent that I should have, and for that again I'm sorry, but I was adjusting to something that I'd never been involved with or exposed with before. And so when it said that I was cavalier, it was that I was on an antidepressant for the first time, and I'm not quite sure how that affected me. I'm still on that antidepressant, and it seems to be working smashingly. But I would hate for the panel to have thought that was one of the things that was most striking to me, was that their belief that I didn't grasp this or appreciate the severity of the nature of my conduct. But that wasn't the case. I was trying to as best I could, but it was as best I could because of what was going on physiologically with me. And like I said, that's why I was the way I was, taking Ativan, which is an anti-anxiety medicine, as well as this antidepressant, and so that is why apparently I appeared the way I did, and I'm sorry. I do understand. I understood the gravity of the situation then. I truly understand the gravity of the situation now, and like I said, for that I do apologize to you.
Very well, thank you. Any more questions?
The formal complaint indicates that you self-reported this,
That's correct, Your Honor.
and what prompted you to self-report in April of 2012?
The short story is that that Ms. Madden had contacted me and had asked me a number of pointed questions, and then said that she had planned on was getting her own accountant because I had not told her the truth about doing her taxes. And at that point in time, I realized that we were going to disengage, and I was shocked that she kept telling me that I was going to do her taxes for her. And so at that point in time, I went back and looked through my folders, my multiple folders, and then went through and figured out the things that I thought after some self-introspection, because it's so easy to point the finger at everyone else, but sometimes it's more difficult to sit down with several boxes of information and say, what did I do wrong? What should I have done? And that's what happened. And then as soon as I realized that I might have a potential ethical problem, I called Mr. Ambrosio.
Good, thank you.
Any more questions? Thank you, counsel.
With the court's permission, unless there's some questions, I'll be happy to answer, but I will waive rebuttal.
Mr. Walzak, I have a quick question. At any point before today, had you heard that the respondent was on medication for anxiety or depression?
I was not aware of that, and I was present during the panel hearing. I had not heard of that.
Thank you.
Any more questions? Thank you. Thank you all for your comments this morning. Court will take this matter under advisement. That concludes